All right, if you're just joining us, we want to reiterate what our colleague Scott Pelley has just announced on a CBS News special report, which is the Ninth Circuit Court has ruled that that temporary ban that was placed on people coming from the 7 Muslim-majority countries in President Trump's executive order should not stay in place. That ban it will, in other words, completely is unfrozen at this point. They're upholding the suspension of that travel ban while the lawyers for both sides, the government and the plaintiffs in Washington and Minnesota, continue to argue on the constitutionality of the president's executive order. We want to get straight to Diana Aizman. She's a lawyer. She was a former district attorney. She's joining us now to help break this down. So, Diana, this federal appeals court, they're maintaining this freeze on President Trump's immigration travel ban. That means that anybody who was temporarily barred from coming into this country from those 7 Muslim-majority countries can now continue to come to the United States. Is that correct?
Yes, that's correct. Essentially, it reverses the ban, and it basically opens up the borders again as they were prior to the institution of the executive order. And it then goes down to the lower court to determine whether the executive order was in fact constitutional. That's the issue that's going to be before the court at this point.
I want to bring in our Paula Reid, who covers the Department of Justice. Paula, you've had a chance to look through the 29 pages. I was fascinated by the fact that all 3 judges ruled the same way. What can you tell us?
Well, we really kind of saw that during oral argument. There was aggressive questioning on both sides, but it was clear that they were extremely skeptical of the Department of Justice's arguments about this. Now, it's important to caveat that the person who argued on behalf of the government here, he only had a few hours to prepare. He was, to put it generously, not at his best. Some other lawyers had to be pulled off the case. So they were really at a disadvantage, both in terms of the skepticism from the bench, but also the strength of their argument. So it's not surprising that all 3 judges went against them and that the travel ban remains on hold until the courts can hash out the question of whether or not this policy is actually constitutional.
And remind us again, Paul, you were saying to us earlier that this was not based on whether this decision today is not whether this ban is actually constitutional or unconstitutional. So what happens now? When will that decision take place?
Well, the first thing is the Department of Justice is unlikely to be happy with this outcome at the Ninth Circuit. Their argument is that they should be able to enforce this policy. They argue it is legal, and they should be able to enforce it until it is found unconstitutional. So we should expect that the Department of Justice, representing the government and the president here, that they will appeal this to the Supreme Court. And then if the Supreme Court accepts it, then we'll go through this again to decide whether or not they should be able to enforce it. Once we get a final answer from the Supreme Court, then it goes all the way back to the beginning, and we start again. But we start again on the question of the merits. Then they really start to get into, whether or not this is constitutional or not.
So, Paula, the Justice Department, obviously representing the Trump administration, if it does go to the Supreme Court, the Supreme Court is 1 justice short at the moment. It is split 4-4. So what would happen then?
So if there's a tie, then it goes back down to the Ninth Circuit. So whatever happened at the Ninth Circuit, it becomes the final decision. We actually saw this happen with the former president, Obama's executive action on immigration. They split on that. It went back down to the lower court. So that's what happens. When you get a tie at the Supreme Court, it's whatever the lower court ruling was, that becomes the final decision. Again, the Department of Justice wouldn't be happy with that, but they believe that the Supreme Court is their best bet right now, as opposed to asking for a full panel at the traditionally liberal Ninth Circuit to rehear this.
I want to bring in Diana as well. Diana, tell us a little bit more about the Ninth Circuit. We know that this is out in the West Coast. What can you tell us, and how does this ruling affect what may transpire in other courts across the country?
The Ninth Circuit is traditionally a liberal as far as appellate court justices go. They are considered one of the more liberal circuits. And I think it will set a tone for the way that this will be received across the rest of the nation. And I think that, as was said, if it goes up to the Supreme Court level and that court splits, the Ninth Circuit Court of Appeals becomes the final say in this. And, I agree their best bet is to go up to the Supreme Court to see what happens there. But ultimately, I think that this ruling will stand.
Diana, the fact that the Trump administration was hoping that they could use national security as an argument to be able to get this ban reinstated, what does this mean, the fact that the president wasn't able to push this forward on the grounds of national security?
So the court determined that they failed to show that entering the stay or the leaving the suspension in effect or the ban in effect would cause irreparable injury. In other words, that there is no irreparable injury by lifting this ban while the constitutionality of the issue is litigated. And that's ultimately, what's been decided by the court. It's just not enough to get over the constitutional challenges.
Paula, we heard the president disparaging members of the judiciary on Twitter and also in comments that he's made over the last couple of days. There were a lot of people who listened to the arguments that were being made on that conference call, and they heard the judges aggressively questioning both sides of the order. Explain to our viewers exactly what was going down. And I know at one point you said that the lawyer representing the Justice Department wasn't as well prepared, perhaps, as one of his other colleagues. But isn't that the role of the judiciary, to question equally aggressively both sides?
Absolutely. I mean, it was what you would call a hot bench. You were getting lots of questions, lots of aggressive pressing of lawyers on both sides about this issue, about whether or not there should be this so-called temporary restraining order. There were a lot of questions, and I think they're not immune to the fact that they knew there were a lot of people listening to their argument, far more so than are listening to most of their arguments. I think there were thousands of people listening in, so perhaps they're even a little more active than they usually would be. But it was nothing out of bounds. It was nothing that seemed super political. These were judges who just really wanted to get to an answer. But you could sense, especially with one of the judges, that there was a lot of skepticism about the government's arguments that day.
The DNC released a statement on this from Interim Chair Donna Brazil saying, let's be clear, this is a massive blow to the White House. The court upheld that we do not discriminate based on religion. That's what terrorists do and what terrorists want us to do. From the 4-month-old infant with a heart defect kept away from surgery she needs in the U.S. to be the handcuffed 88-year-old blind man denied a wheelchair, thousands of decent, peaceful people have already been hurt. And all of us are less safe. President Trump still lacks the judgment to see the pointless chaos and harm he has caused. Our courts, thankfully, do not. We are confident this ruling will stand. Paula, it's fascinating. It's been fascinating to watch a bit of a civics lesson here the past couple of weeks of seeing the courts check the executive branch.
It is. I usually think I'm the one who gets the most excited in any room about the Ninth Circuit or about an appellate argument. And then, the whole country is watching this. They're very curious. And it's funny because really, to be honest, we're pretty deep in the weeds in terms of procedure right now. We're arguing about whether or not a temporary restraining order should remain in place. This isn't a big constitutional question yet, and yet the nation is riveted. And there has been this pushback from the White House, and now the Supreme Court nominee pushing back on that pushback. So it is. It's truly fascinating, and I, as a reporter who covers this, I'm excited that everyone's as excited as I am.
Diana, I want to ask you, one of the things that I think has been fascinating as well is the fact that when Washington State brought this to the Ninth Circuit, they were arguing that members of the community of Washington State, including the university and other agencies, were being affected, harmed, in fact, by the president's executive order. But then Judge Robart, he actually expanded the order to include anybody coming from those countries who were not even in the state of Washington or in the United States. He made it sort of a global order. What did you make of that?
I think that the issue is going to be standing. I mean, ultimately, that's kind of what he's shining his light on here, is that there may be a standing issue, but when it comes back down to the district court level when they're litigating this. And I think that there needs to be a showing that the state of Washington does, in fact, have an injury that gives them standing to bring this to the court in the first place. And so I think that by expanding, who the injured parties can be, it's definitely going to help in that standing argument at the district court level.
Fascinating case here. We are, of course, the verdict in that Donald Trump's administration has lost the court battle to reinstate the travel ban. It will stay in place. I want to ask you, Paula, you were talking to us a little bit about strategy, but if you are part of the White House legal team right now, what are you doing?
You're going to appeal this to the Supreme Court. At least try. You've taken it this far. I mean, go all the way. See if it'll work out. Because truly, if you're thinking strategically, if you're just thinking through a legal lens, the best thing to do would be to take this back and redraft it in a way that it would ultimately survive Supreme Court review. And in order to do that, what you would do is you wouldn't make it such a blanket ban. You would have carve-outs for people who have green cards, people who got visas because they helped the U.S. military. You could make some tweaks to this policy, still have the same spirit, but have something that's much more likely to survive judicial review. Right now, I mean, they've been warned by a few judges that they don't think this is actually going to hold up in the end if they can get past standing and all these other questions. They think this looks like religious discrimination, the judge suggested. So if I was in this White House, I think they're probably going to appeal it to the Supreme Court, but just with the background knowledge that really the best thing to do is probably to just tweak this a bit.
And this is all born out of these executive orders, Paula. Does this case say anything when it comes to executive orders?
I mean, it's just another test for the president and the extent of his or her power. President Obama certainly got a lot of criticism and pushback in subsequent litigation for his executive action on immigration. He was trying to do something a little bit different. But it's important there, we never got a final word from the Supreme Court on that because they split. So it's a novel question that really is ripe for the Supreme Court to take up again and look at just, how far does this power extend? Although this is probably less about the president's power and more about religious discrimination. And
Diana, let's talk about that question of standing, because there was a judge in Massachusetts who found did not come to the same conclusion as the judge out in the West. So what was the difference there? Explain to our viewers why one judge in Massachusetts would come to one decision and another in another state would find a very much different one.
Ultimately, what it comes down to is that they didn't have a plaintiff that the judge felt had enough of a dog in the fight, or, that there wasn't enough injury to that particular plaintiff to give him a reason to bring forth an action before the court. And in in Washington, the court did find, or at least they're finding that there is going to be a standing for these particular plaintiffs, and they're going to be able to continue on those issues. And ultimately, that's just what it comes down to. That's what the definition of standing is. And it is a prerequisite for being a plaintiff in any case in the federal court.
Does it make any sense, Diana, and perhaps, Paula, you can weigh in on this as well, for the government just to go back to the drawing board and put together and ask the president to sign an executive order that can be implemented properly, that doesn't have these questions of constitutionality attached to them? Or is this, are they in too deep and they got to go with what they have?
No, I think if you're a member of the White House at this point, you want to restructure the order so that it doesn't look like a violation of the Equal Protection Clause, so that it doesn't look like a violation of the First Amendment, so that it doesn't blatantly scream of constitutional violations. You want to make it a little bit more tailored, something that's more palatable, and it's not going to be challenged so vigorously in the courts.
All right, Diana Aizman, Paula Reid, thank you both very much. We appreciate it.
Thank you.